Hi you guys, Martise Brumfield here with Martise Brumfield Real Estate, and I want to welcome you guys to this edition of our series. I have with me today Kanumi Mapatal, who is a probate and family law attorney. And just to kind of give you guys some background, you know, when I am prospecting and doing my lead generation, I come across a number of individuals who have property, but they don't necessarily have their properties in a trust or anything like that. And so I thought it would be a good idea for us to provide you guys with some information about living trusts, wills, and the difference between the two. And so I'm going to turn it over to Kanumi, and we're going to share some information that we pray and hope that will be beneficial to you and your family. So, Kanumi, first starting off, can you share specifically what it is a living will or a trust?
Well, let me make a correction though. Like
Okay.
Ms. Brumfield said, she likes to start off laughing. So she actually made a really, really funny joke when she pronounced my last name.
Okay.
And my last name is pronounced Ma'atafali.
Ma'atafali.
A living trust is basically a three-part document that relates to the individual who creates the living trust, which is a trustor, and the people who they're trying to give stuff to, which are the beneficiaries.
Okay.
And in that scenario, you're creating a relationship in which the trustor and the beneficiary have a fiduciary relationship.
Okay.
And then the trustor, what they do is they create a individual who is the trustee of the trust.
Okay.
So you have the trustor, the settler, you have the beneficiary, the person who's receiving it, and then you have the trustee, is the person who's supposed to carry out the wishes of the trustor or settlor. So that's what a living trust is.
Okay.
And again, a living trust, why they call it living, is because the person who's created it is still alive while the assets themselves are in the name of the trust.
Okay.
And so then what ends up happening is that person or individual can still control their assets while they're alive. And it's when they pass away that now the trustee has to do whatever the trustor had wished for, again, the beneficiary.
Okay. And so can you give us a clear distinction of the difference between a living trust and a will? Because you just explained the living trust, so which one is more beneficial to have upon, death?
Well, a will sort of creates the same type of scenario again, where you have a person who creates the will. Again, there's a beneficiary of the will.
Okay.
The assets themselves, though, don't go into the name of the will.
Okay.
They stay. So if you have a house, the house stays in the name of. Whereas in a trust, it's in the name of the living trust.
Okay.
And again, there is no trustee. There is what they call a executor of the trust.
Okay.
So, for example, if I created executor of the will. So if I created a will, I would say I would want all my assets to go to, let's say, my children. But I want the person to pass out those assets to my children to be you, Miss Brumfield. But what happens is the difference between a living trust and a will is that a living trust, if I made you the trustee, you can carry out those wishes without having to go to court.
Okay, great. Okay.
With a will, the only way you can carry out my wishes is to go to court first be appointed the executor of the will.
Okay.
Because again, all the assets, remember, are in the name of me, the individual.
Got it. Okay.
And so in order for you to carry out my wishes, because those assets are still just in my name, you just can't go show the banks or the mortgage people, hey, I have a will. They won't accept that.
Okay.
Whereas in a trust, you don't have to do that. You can wave the trust around and say, I'm the trustee, and the individuals, because all the assets now are in the name of the trust.
Okay.
And so now you get to go out and carry out my wishes.
What are some of the consequences of not having either one of these in place? I know you shared with our audience so far that if you have a living trust, they don't have to go to court versus where you have a will, you do have to go to court to be appointed
An executor.
as an executor. So what are the consequences of not necessarily, let's say, having either of these items in place upon your death?
Again, the consequences are now, whereas in a trust or a will, you're able to dictate who you want things to go to.
Okay.
So whereas if you don't have those, now you basically have died intestate.
Okay.
Intestate means you die without a will or a living trust.
Okay.
And so now you have to go to court again in order to ask the court to make you the administrator of the estate.
Got it.
And in doing that now, the state of California has a succession upon which assets are to go to heirs.
Oh, wow. Okay.
And so when you don't have either, it goes to your children first. If you have children, if you have a spouse, your spouse gets a certain percentage and then your children get another percentage. And then if you have neither a spouse nor children, then it goes to the next of kin, which may be your siblings. If you don't have siblings, then it goes up to your parents. So there's a succession upon which, if you don't have a will and or a trust, it goes in that based on the California law. In a living will or a trust, you can exclude people if you want to. If you don't like your you don't like a child.
We hope that's not the case.
Again, you will be amazed at what people will do in their trust or wills. Because again, the good thing is,
because it's their choice, it's their decision.
Yes, you know how your kids treated you while they were growing up and until you became adults. And that's what it primarily does. For most people, it's the exclusion of people if they choose to exclude them. Or for the most part, you may want to give, to a church or to a charity and not to your children. And again, in either one of those, you're able to do that. You may love your God or your church a lot more than you love your children. And people do give things to their churches. And so in a living trust or a will, you're allowed to basically tell us who you want to give those things to.
It's my understanding that too, a will can be contested even if it's in place with someone upon their death, correct? It can be contested by, maybe the children or someone who believes they are entitled to, maybe assets of the estate.
That is true. So again, when you create living wills or living trust or a will, in that scenario, most of those have what they call no contest clauses. Meaning that if I didn't put you in there and you go in there to contest it, for the most part, you're still going to get nothing anyway. People do contest them when they believe, for example, you have people who have Alzheimer's. And the person who was taking care of that person in the house, somehow a will or a trust was created when the person had Alzheimer's, giving all the assets to the person who was caring for them.
Got it.
And in that case, the other siblings or family members would step in and want to contest that because they'll show that she was not capable of signing it, in the right state of mind of signing it, like I say, was under duress. So in those scenarios, yes, those types of things can be contested.
Bringing it home a little bit more for our homeowners who have property, who have assets such as real property. If they want to refinance or sell a property, is it necessary for them to actually pull that property out of the trust in order to refinance or sell?
Again, the beautiful part about having a living trust is you're still the owner of the asset. So when you do a living trust, you have to fund it. And so what they mean by funding, you have to put an asset into the trust in order to make it valid. And so you can put $1 into the trust, not figuratively, but not literally, but figuratively, saying, there's $1 in the trust. Or what most people do is they change the names of their title from them to the name of the living trust. And so again, although now the title is in the name of the living trust, if you want to sell it or refinance it, for refinancing purposes, for the most part, I don't recall if they make you take it out of the name of the trust to do it. They may not have you do that. But if you want to sell it, again, for the most part, you can take it out of the name of the living trust, put it back into your name, sell the property, and be done with it.
Real quickly, what is the recommended time frame? Let's say I have a homeowner who recently purchased their property as maybe a first-time home buyer, or maybe someone who's already a homeowner. What would you recommend? What's the time frame that you personally recommend someone putting their real property into a trust?
Again, for the most part, it really just depends on who you want the asset to go to.
Okay.
So
there's really no particular time frame in which to do it. Okay.
So if you don't put it in a living trust, what you're doing is you're creating expenses upon your heirs or the person who you want to administer your estate.
Right.
And so
you're just giving away money by not actually protecting your assets and clearly stating how you want them to be handled.
Well, you're losing money when you don't put them in a living trust.
Okay.
Because the living trust is the only thing that keeps them out of court.
Got it.
A will or not a will, you will always have to go to court.
Okay.
And so, for example, if you hired an attorney to do the process, the code section says whether it's a will or intestate, whether you die without a will or a trust.
Okay.
But if you have to go to court, the court automatically says, the California code automatically says that an attorney gets a certain percentage of each $100,000 is 4%. You get 4%.
Okay.
The next $100,000 you get 3%. So any asset that's over $200,000, the attorney is receiving 7% of that.
Oh wow.
Anything between $200,000 and $1 million or the next $800,000 is another 2% of that portion.
Okay.
And again, with the way that real estate has arisen in California, you're already at 9% giving that to an attorney to process the paperwork.
Okay.
And so to answer your question, really would be as soon as you determine that you'd rather have your asset protected and your heirs not having to go into court.
Okay, that makes sense. Is there any other benefits outside of just simply stating who we want our assets to go to? Is there any type of tax break or anything like that, or a shelter, if you will, having your assets in a trust, your real assets in a trust?
Well, again, depending on who you're trying to protect.
Okay.
So, for example, a living trust, you can protect people getting some form of state aid.
Okay.
So what happens is some state agencies, when you receive an asset, the state agency says you have to live off of those assets before we'll continue to give you benefits.
Okay.
So you can create what they call special needs trust, where the person who, let's say you had a disabled child who was receiving some type of benefits from the state, and for whatever reason, if they receive an asset, the state just cuts off those financial benefits.
Got it. Okay.
Right? So if you did what they call a special needs trust, because your asset, you don't want your asset to go to that child, for the state to consider that an additional income or additional monies that they have. Okay. You put it in a special needs trust.
And then lastly, of our audience who would like to get in contact with you and ask you maybe some questions, are you available for that? Or, you know, what is your process for them maybe calling in as a result of seeing this information? Can they call you, and what's your contact information?
Okay.
Can you share that?
You can call me. My cell phone number is 323-595-1200. Call me 24 hours a day, 7 days a week. For the most part, I'm available when I pick up. If I don't pick up, you can always text. My email is kmt.ampah@excite.com. You can always reach me there. And either through phone, text, or email, I'll return them. And then, like I said, if you have additional questions, you can call Ms. Brumfield, and she's been able to get in touch with me.
And you know what? That's one of the things that I really do want to say about Kanumi here is the fact that anytime I call him or reach out to him, he has always been helpful. He answers any questions I might have. He picks up his phone, which is what I really like, because there are some attorneys who do not. And so I just really want to thank you for that, because not a lot of attorneys are that responsive, you know, when it comes to, you know, their work ethic. So I really do appreciate you taking my call, and not only taking my calls, but answering my questions that I have. we are working together right now on a case. And so again, for those of you who have any questions about your financial planning and planning your estate, feel free to reach out to Kanumi. He's available, and we will also provide you guys with his contact information at the end of this video segment. So be sure to subscribe to our YouTube channel, where you can find a great deal of information on how to protect not only you, but your family as well. And thanks, you guys, and we'll talk to you soon. Take care.